In today's video, I'm going to talk to you about civil theft notices in Florida. My name's Adam Rossen. I'm the founder and owner of the Rossen Law Firm, a criminal and white-collar defense law firm in South Florida. I'm a former prosecutor, and we've handled hundreds of these cases, my team and I, and we have over 600 five-star reviews on Google all over the internet. And by the end of this video, we want you to know everything there is to know about civil theft notices, what happens and how they come about when you get a shoplifting charge. So let's say you get caught shoplifting, right? And you get caught, what happens is you're leaving the store, they wait for you to pass all points of sale, okay, basically get through the exit, and then they stop you. They recover all the goods. You get charged with shoplifting, whether you're arrested or you get a notice to appear. And you think, right, okay, all I have to do is defend against this criminal charge, right? Well, guess what? Wrong. Florida has what's called a civil theft statute. And what these stores do, Publix, Walmart, Target, right, all of the big ones, what they'll do is they will hire attorneys who will then send you a civil theft letter from a law firm on behalf of the store. So the Florida statute that this involves is statute 772.11, 772.11, and it's called Civil Remedy for Theft or Exploitation. And what this statute does is it sets minimum damages at $200, whether anything has been taken or not, whether there's been any actual damages. It sets a maximum damages at what we call treble, or 3 times the loss. So if there actually is a loss, they can get up to 3x of that loss. It also provides for reasonable attorney's fees, court costs, and the statute says is that if you are a minor, so let's say you're 16, 17 years old, and you live with your parents, then they can actually sue your parents. Okay, so it's kind of crazy that this law is out there, and most people don't understand what this means and how this is going to affect them if they get a shoplifting charge. And then lo and behold, they get a letter, a week, 2 weeks, 3 weeks later saying, we demand you pay $200 and, blah, 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 or else we're going to sue you. And the real kicker with this, the real thing that sinks teeth is the attorney's fees provision, because if they went to litigate all the way through, they could rack up $10,000, $20,000, $30,000 in fees to try to collect a few $100s, against you. So that part's a little scary for people, and really puts these stores in a tremendous, position over you, which I think is completely wrong and very unfair. So here's an example of a letter, the civil theft letter, from the law office of Michael Ira Asen. They're a law firm in New York. They're not even in the state of Florida. And here's a copy of the letter so that way you folks can see it. And, more or less, it's a legal shakedown letter, right? It's a letter saying, hey, pay us this or we're going to sue you, whether they recovered anything or not. So when you get a letter like this, you really have 3 options. Option number 1 is do nothing. And we can't always recommend that. And here's why. There's always a chance that they will do something. And if they do sue you, it could be worse. What will happen is if you ignore the first letter, usually they'll send you a second letter saying now they want $400 instead of $200, and they're going to sue you. And again, that can be very scary. I can tell you on this video, I have never, ever, ever seen that law office or any of these law offices sue my clients, okay? But I, as an attorney, can never tell my clients to just ignore something, right? Because what if it's the 1 in 100 or the 1 in a million, 1 in 1,000, whatever it is, where they actually will sue the client, right? So all we can do is advise the client that, hey, I've never seen this happen. If you want to ignore it and not pay anything, then that is your choice and your decision, understanding what the pros and cons are. Option 2 is you could have your attorney call them to negotiate a lower settlement. So I've had some clients that were, little nervous and cautious, didn't want to blow off this letter, certainly didn't want to get sued. And they said, well, Adam, can you call to just try to lower it to maybe $100 or $50 or something like that? And we've had a few clients that we've said, sure, no problem. We've emailed them, we've called them and said, hey, look, I know you're not going through this whole process. My client's willing to pay $100 or $50. Let's just settle this and send us the release and be done, and you guys can at least collect something. So that's an option for clients as well. The third option is just have the client pay it. If the client doesn't want to deal with this, it's causing too much stress and and anxiety, and they don't want us to negotiate, or they don't have a lawyer, right? You can just call them. You can just pay it. That is your right? So, and that's what the law firms are banking on, right? They're banking on they're banking on fear. They're banking on that you're just going to go ahead and just pay, and they're just going to collect $200, kind of like Monopoly, right? Pass go, collect $200, $200, and when they do that at scale, they're making a ton of money off of these civil theft laws. Again, which I really just don't agree with, but that's the way that this system works. So, we here at the Rossen Law Firm really believe that knowledge is power. We want people to know what the law is, be empowered. That's why we make these videos. So if you ever have this situation and come through, you need to find an attorney that deals with these, that knows these, and can properly advise you. If you ever have any questions about anything criminal defense related, theft related, anything that we do, especially in South Florida, you can give us a call at any time, 754-206-6200. You can visit us at rossenlawfirm.com, and we'd love to help you out and give you more information.